Hello, my name is Mary Mack, and I'm the Executive Director of ACEDS, the Association of Certified E-Discovery Specialists. And we want to welcome you to our ACEDS webinar channel. We have a wonderful product and service showcase for you today called Redactions Managed Right, Workflows Maximizing Relativity Analytics and Apps, a Practical Navigation Roadmap for Litigation Support and Counsel. We are so grateful to our affiliates like Evolver, who is sponsoring this webinar and participating in this webinar, bringing the technology to us, the hands-on technology, the in-the-trenches experience in using the tools that we need to discharge our obligations to be technically competent. And whether we're attorneys or serving attorneys, we all have that obligation. We have just a star-studded panel to discuss this with you today and to demonstrate these workflows, tools, and apps. First, I'm just so pleased to welcome David Cohen from Reed Smith. He is the chair of the Records and E-Discovery Group. And David's been involved in e-discovery, I think, before they even called it e-discovery, and an early mover in the space. Been very generous with his time to educate the community and to build teams and processes that sustain the very, very large cases. So he's got over 30 years of commercial litigation experience in all sorts of different subject matters. So the subject of redaction, I think, is near and dear to his heart. We also have with us Jeff Gillis, a solutions architect and thought leader at Relativity, and prior to that, he was with Content Analyst, one of the great tools that Relativity has seen fit to bring under its umbrella, and he's been working with Kakura, the precursor branded name to Relativity, since 2008. And he is also doing consulting and devising workflows and optimizing the Relativity product set. And we also have Mimi Singh, who is returning to our webinar channel as the Director of Consulting, and she's a Relativity Master, something that's not easy to earn at Evolver, and she's the Associate General Counsel in addition to the Director of Consulting, and so she'll be bringing the in-house service provider perspective and drawing on her long experience with litigation to this particular webinar. So I'll be taking the questions in the Q&A window down below, and I think we've got someone who's got a little bit of background noise going on, so if we can mute, that would be lovely. So I'll be taking your questions. We're very interested in your questions, but we'll be saving those for towards the end, and we'll be leaving time for those. And the things that we don't get to in the webinar, we'll make sure that you get a reach out. The slides will be available after, as well with a link to the recording. So without further ado, Mimi, please take it away.
Thank you, Mary. Evolver is pleased to be a sponsor, and we thought this rather timely. We've seen redaction in the news, and I think all of us in our own way are familiar with the e-discovery and document review costs consistently trending upward. And so the purpose of this webinar is to provide concrete recommendations for belt tightening, essentially by leveraging technologies, workflows, and human judgment for which there is often little substitute. So on the technologies piece, as Mary mentioned, this is about Relativity offerings, their core functionalities, and apps from Relativity partners. Quite a bit of our discussion will be platform agnostic, but the emphasis is on Relativity. We're very glad to have Jeff Gillis of Relativity, who's on the panel, and who will be moderating today's session. Jeff?
Great. Thank you, Mimi. Mimi and Dave and I were able to meet in person last week at Relativity Fest. Today we're distributed, so I think we'll have a really good and vibrant discussion here. And I really do hope that we can deliver some concrete recommendations for people. Before we get into some of the recommendations, we thought it would be appropriate to kind of set the stage, though, and really talk about the problem of redactions, the controls around that, and to really set the stage so that we can get into the solutioning. So we're going to have Dave, if you want to take us through kind of setting up redactions. What is the type of content that we're typically needing to redact, and also what are some of the controls, depending on the jurisdiction, depending on the situation, that govern the types of redactions you're doing and the nature of those redactions?
Sure, Jeff. One of the most common challenges in litigation discovery is dealing with privileged documents. And while the law allows us to withhold documents that are entirely privileged from production when we're faced with discovery requests or government investigative demands, very often you're going to have some documents that have some privileged content, but other content that may not be privileged but is still relevant to the matter at issue. As an example of this, we sometimes run into a company's meeting minutes, and maybe one of the things they discussed during the meeting was a legal issue where the lawyers weighed in, and there's some legal advice in the minutes, but there's other parts of the meeting minutes that are relevant to the matter that aren't privileged. And so in those situations, you would still be expected to produce the minutes even though they're partially privileged, and you would redact out the privileged portion. That's just one example. We're frequently doing redactions, privileged redactions for documents that are partially privileged, partially not privileged. Another type of redaction, which is very common, is to redact personal data or PII, personally identifiable information. And sometimes there's documents that have individuals' personal information, whether it be social security numbers, bank accounts, other sensitive information that may not have any relevance at all to the litigation. And in order to protect the personal privacy of those people, we would redact that information before the documents are produced in many cases. And same with personal health information, PHI, or information subject to the Health Insurance Portability and Accountability Act of 1996, in other words, HIPAA. That information, there's obviously restrictions about how you handle it, legal restrictions, and very often necessary to redact that information in order to protect confidentiality in a discovery context. You get into a little bit of a more gray area when it comes to non-relevance. So there's no particular rule of civil procedure which says that you can take a document that's otherwise relevant and redact the non-relevant stuff, but on the other hand, the scope of discovery is only what is relevant and proportional to the matter under the federal rules. And very often companies will have information that not only is it not relevant, but it might be sensitive for various reasons. For example, it might have proprietary or trade secret information. It may have to do with products other than the products at issue in a particular case, and therefore not go to the claims of the other side. And in those cases, parties will often want to redact that information. Sometimes that's handled with agreement.